Hello viewers, welcome to our program on immigration and legal affairs. I am your immigration attorney Michael Fulwani, and once again we have with us attorney David Nachman.
Thank you.
David, welcome.
Thanks so much.
I have an interesting question. I'm glad to actually ask this. I'm glad that this question is asked because this is very important for us also. That this question is from our viewer who is in Phoenix, Arizona. And he says that he's on H-1B visa presently. He says, I have my employer who says that he's going to apply for my labor certification in January or February 2012 because of financial or whatever reasons it may be. But his problem is that his 6th year is going to expire in October or November of 2011.
Okay.
So I think that could be a problem.
That could be a big problem.
Big problem because if he wants to get a 7th or 8th year, if it's, let's say it's expiring December 2012,
Right.
and he applies before, let's say the next 1 or 2 months only right now, the perm application probably takes few months and all that. But even the application, pending application of the permit is okay for the counting the 1 year period. Doesn't have to be from the date of approval, the 1 year period. That's even while the labor certification is pending for 1 year.
That's right, Michael, as long as it's pending for 365
So the
days.
best advice for this person is start the case now.
As soon as
Because
possible.
if you wait that long, then you may not be able to extend the 7th or the 8th year. Then your option will be go back to India for 1 year and stay, and then you can have the 6 year period to start all over again.
That's right. And Michael, one of the most popular questions that we get in our office has to do with how do I approach an employer to try to get them to help me to initiate the labor certification process. And there are all kinds of different ways in which we can assist you to think about the right time to do it. For example, maybe it's coming around time for bonuses. And maybe what you want to do is you want to say to the employer, well, here's one great way that you can show your appreciation to me as an employee, being a dedicated employee. Help me to do this labor certification because I really need it so that I can extend that H-1B.
And don't forget, the application for labor certification is to be filed by the employer, not the employee. So it's basically up to the employer, but as David suggested, you can pursue it. And then sometimes the employers have some kind of hesitation. And I tell the client, listen, ask your employer, call me. I'll be more than happy to talk to the employer.
Exactly.
Explain him it's not the end of the world, it's not a very big huge thing. Oh, my employer is sponsoring, oh, the government is going to look at me, what will be my problems and all that. It's not that big a problem. Basically, if they talk to a good lawyer like me or David, he will be very happy, satisfied that, okay, this doesn't seem like a big problem, I should do that.
It's a great point that you make, Michael, because actually what happens is an employer has gone through the LCA, labor condition application process with regard to the H-1B, but then they don't really understand fully the labor certification process. So an attorney like Michael, like myself, we can talk to the employer and we can explain to them what exactly is involved. We provide white papers that explain step by step what the labor certification process is through PERM, using PERM, how to do the recruitment, and that it's not going to be tremendously onerous for the employer to do this process.
This person has got another question. He says, do I have to find a lawyer in Phoenix because I live in Phoenix? But I like you very much. You know, David also, Michael Fulwani, we like you guys. And how many you guys are in New Jersey? How can you represent me if I hire you? And my answer is, I'm sure David's going to add on that US immigration law is a federal law. In most cases, you don't even have to go for interview, or the employer doesn't have to even go for interview. All the work basically is paperwork done. We can do paperwork for any client anywhere in the United States from our New Jersey office. This should not be a problem. I mean, there are some cases, family cases, for example, where, or in some cases in employment situations also, it may be necessary, the immigration service may decide for the person to come for an interview. Not a big problem because me with 40 years of experience, I know immigration, good immigration lawyers all over the country. So what we do, we'll prepare all the papers properly, legally, file them, get the labor certification approved, get the I-140 petition approved, and even file the 485. And when the time comes for interview, we always, David and me both know lawyers all over the country. We pick up a good lawyer, pick up a phone and tell him, John, Bill, whatever, I have a client, I just want you to help him, I'll send you the papers and I'll discuss with you, I'll explain to you about the case, take my client for interview and we'll take care of you. So it's not a problem at all. What do you say, David?
I absolutely agree. Michael, you're absolutely right. Immigration law is a federal practice. We represent clients throughout the country.
Correct.
And as
For
far
the world, actually, I get clients from all over the world.
yeah, as far west as Honolulu, as far east as the United States goes. And we're able to file cases for them anywhere that they need it done. Now, there is some truth to the fact that some people do like to sit down with their immigration lawyer and to talk to them face to face. And if that's the case, that's probably why the vast majority of our cases in our office come from the East Coast, because that's where we're located. However, we do have a representation throughout the whole country.
See, in many cases, people have relatives here in New York, New Jersey, and they come and see me, David, that I want to apply, or I want you to help my nephew in California or Chicago or any place. It doesn't matter. We do on the phone. We have FedExes these days, emails. Very soon we may have even a teleconferencing and those kind of things. So that is not a problem, and absolutely don't have to worry about that part. Okay. I have a question here from a client, actually. Also, same question I got from some viewers also. And he says, I am a UK national. He has a British passport.
Okay.
He came to US in January of 2011 on a visa waiver, because there is a visa waiver program between some countries and the United States, and the US has permitted those countries, they don't need a visa to visit. They can come and visit for 90 days as long as they have the passport of that country. So this person, UK is one of those countries where there is a visa waiver. He did not go to the consul to get a visa. He got on the plane, came in, and at the airport they gave him 90 days. And under this visa you cannot extend the visa, or you cannot change in most instances. Correct. So he has this concern, because he has gone now overstayed for some time now, and he found a nice girl who is a US citizen. He wants to get married to her, and then his question is, can I get a green card in the US without going back to UK, or if I go to UK, will there be problem? I would say, first of all, if you are staying here in unlawful status for more than 6 months and you get married to a citizen, don't go to UK, don't even think about going back to UK, because you will be incurring unlawful presence, a 3-year bar. Or if you stay more than a year illegally, 10-year bar. But the good news is that as long as you enter legally, even on a waiver visa, you can apply for adjustment of status. In the US, you get a green card right here, and they can tell you about something. Once upon a time, there was some period of time that the government said, no, if you came on a visa waiver, you got married or whatever, you want to apply for an immigrant visa, you must do that within that 90 days period. Because you overstay, then we will not permit you the adjustment of status.
Right, Michael. Actually, you're talking about the Bradley case, which was here in the Third Circuit.
Came from there.
And yeah, and it's interesting because in New York they were unaffected by that,
Exactly.
but in New Jersey we were affected by that for a very short period of time. But now it seems to be the case that they are saying
Yes.
it's not a problem at all. If you entered on the visa waiver.
Recently also, as of yesterday, they said no problem at all, you can apply. Policy has changed now.
That's correct. As long as you entered on the visa waiver, it was a valid entry, and you can go ahead and adjust your status to the United States. And what you pointed out, Michael, is absolutely right. If you've accrued 180 days of unlawful presence in the United States, then what will happen is if you depart, and the departure is the trigger for the bar,
Exactly.
then you will be barred for either 3 or 10 years. And that's a big problem under the law. That's under 212A9.
Yeah, people, and we've seen a lot of cases, people don't understand that. They only look at the April 30, 2001 date and apply, oh, I have a 245I, oh, I have a 245I. When they apply for the immigration says, okay, show us the proof that you were here on a December. Now, David, it's unreasonable to pick a particular date, December 21, 2000. But immigration is a little flexible, I would say, that a few days before, after that, and they see a total period of time. It's not likely that you might have left on 18th of December and come back on 31st of December.
Well, we've had a couple of cases like that, Michael, and why don't we take a short break, and then when we come back, what we'll do is we'll discuss some of the ways in which people can demonstrate that, in fact, they may have been here on that particular day.
Yes, it's time for a short break, and we'll be back after the break. We'll continue this discussion with David and me. We're going to talk more about this particular problems and how to get around some of these things. Stay tuned, we'll be back.
On the 245.
Welcome back. Once again, David is with us, and we were before the break talking about various ways we can get around some of the problems. We were discussing about section 245A and the 245I. David, go ahead.
Well, as a matter of fact, Michael, what we were saying is that some of the officers, when you go to interviews, which seem to be noticed now on the 245I issue, what they're doing is they're saying, prove your physical presence on December 20th of 2000 in order to gain the benefit of 245I. And that's a very difficult proof to make. And what we tend to find is that the officers have a tremendous amount of discretion to decide whether or not a person truly was here on that particular date. Now, as Michael pointed out right before the break, how do you prove that an individual was there on that particular day?
I don't even know why they pick up that one date, December 21, 2000.
Well, that was actually the date that the law was passed.
So
that's when the Life Act was passed. So they say it has to be that as of the date.
Practically speaking, person can prove I was here the whole year. Yes, maybe.
Yeah,
but on a particular day, anyway.
Yeah, no, you're absolutely right. It's that, but that was the day that they chose in the regulations.
We have been, David and me, we have been advising clients to have documentation, like if they might have seen a doctor, they may be in a hospital.
Medical records, excellent.
They may even get a ticket. Wrongly parked.
Correct. We use photographs. We look for photos that have dates on them.
Correct.
We look for school records of children maybe who have been in the schools who were minors. We also look for things like, and sometimes they'll have them as paychecks. I just recently...
David, the problem with the police, there's a little fight between husband and wife, and they call the police 911, and they came on that day, and then they get them summons or some. The legal record of the police that they were there, whatever it is.
The legal records are good. Tax returns,
yes.
Having filed the taxes, maybe a year before and maybe a year after. And that way they can interpolate to say, okay, if they were here filing legal records before and after, maybe then they were here on that.
So there's always a way that if you go to an experienced immigration attorney and he can guide you properly, as I do, and David says, we never say, just come to us only, and we are the only lawyers in the United States. Wherever you are living, find a lawyer that is good, that is experienced. Obviously, I am here, David is here, and anytime you need any of us, we'll be more than happy to assist you. David, we still have some time left. Let me ask you a quick question. Just give some highlights quickly. A person doesn't have a family, person has nothing else. The only way for him to get a green card is based upon sponsorship of an employer. So what are the different steps? How long does it take? And what are the kind of problems a person can encounter going forward?
Okay, well, generally, Michael, when a person comes to our office who's looking for sponsorship from an employer, they're usually coming to us, I guess, first in a period of time after they've studied called OPT. OPT is what we refer to as sort of the honeymoon period, where the employer is getting to know the employee a little bit. And then what we do is we counsel them to move to a non-immigrant visa, like an H-1B, or some other type of non-immigrant visa classification where they have more flexibility, longer-term classification, some kind of an underlying non-immigrant visa that's going to be long-term. And then what we do is we start to look at their green card options. Now, obviously, we discussed briefly before, going to the employer, making to the employer to understand the various steps that they need to take in the labor certification process.
The labor certificate, advertising and all that.
So what we do is we use the baseball theory of PERM. When I describe the PERM process to my clients, I say, do you understand baseball? Now, usually a lot of my clients say, no, I understand soccer and cricket. And I say, well, unfortunately, I haven't developed the analogy for soccer and cricket for PERM. So let me explain to you the baseball analogy for the labor certification process. So step one, or first base, is to get the PERM labor certification approved by the U.S. Department of Labor. And what that does is that requires recruitment. And there's a very specific step or steps of recruitment that have to take place where you demonstrate that there are no U.S. workers who are able to take a particular job that's being offered to the foreign national.
Unfortunately, we have seen that problem happening. Some inexperienced, unethical lawyers, they stuck any case that they get, they take it, they want the money, they're interested in taking the money. And when they do not do a good job, it gets denied, and they will never say it was my fault. It will say, oh, the Department of Labor did that and all that. So the good advice always is that take your time, there's no rush. Basically 2 days, 5 days a week, 2 weeks, talk to your friends, talk to your relatives, go on the Google, go get information about the experience of the attorney, how long has he been practicing, talk to your friends, relatives, get some good advice, pick a lawyer that knows how to do a PERM case, how to go for I-140, how to go for the foreign.
Right, which is second base. The I-140 is the second base.
So let's say labor certificate approved.
After the labor certification is approved, you go to second base.
So
second base,
let me add
yeah,
something.
sure, of course.
After getting a labor certification, you have 6 months within which to file an I-140. People miss that. Okay, I'll do that. Employer says, okay, what's the rush? What's the rush? What's the rush? 6 months go by.
Because the regulations require that you act
Labor
on
certificate is invalid.
you act on it within 6 months. Exactly, 180 days.
Sorry, 180 days.
Right.
You must file I-140. Employer has to file, not you. And in the I-140, what do we have to submit?
You have to, well, it's a good idea to submit at that point proof that the U.S. employer has the ability to pay the employee the pro-offered wage, which was designated by the federal government in the prevailing wage documentation, which was the underlying part of the labor certification.
I see a lot of denials of I-140s, mainly for the ability to pay.
Yes.
Because when the person requested a restaurant or some small grocery store and pressurized him, please help me, he said, okay, I'll help you. The lawyers, many lawyers don't even tell them about the problem that may come in the future on ability to pay. Okay, give me 5,000, this 1,000, they applied for a labor cert, they filed I-140, insufficient income, denied, end of the story.
That's right.
So the good lawyer will go through from the very beginning, first base, second base, third base.
Third base is the adjustment of status or consular processing, and then of course home run is the green card.
Okay, so you know now that our next guest is a Canadian immigration lawyer. Stay tuned and we'll be back with the latest information on Canadian immigration laws. We now have it.
Watch Aapka Aaj 7 AM every day on TV Asia.
Welcome back. We now have with us our Canadian immigration lawyer, Veronica Malka, as we say in Hindi, Urdu. Welcome back.
Nice to be here, Michael.
So tell us.
Well, yes, that's correct, Michael. We don't have an alphabet soup in Canada. We have a point system. The point system is under the Federal Skilled Worker Program. It calculates the points awarded to an applicant based on their work experience, their potential job, if they have a job waiting for them, their age, their education, and their adaptability. For example, if they have, again, a job waiting for them or a relative living in Canada, that will also score them more points. The current score mark is 67. There's some discretion to have a little bit less than that and still be able to apply. And of course, the more points you have, the better. The score also depends on the language tests that a person will apply for to speak either French or English. And depending on that score of the test, they'll get a certain amount of points.
So David or me, let us say we decide to immigrate to Canada. You think we get 67 points?
I would assume that yes, you would, based on your level of education and the other aspects of
Thank you very much. Thank you very much.
If you don't have a criminal background, of course.
Okay. All right.
Veronique, can you tell me, would you recommend that people do their own calculations?
Absolutely not. I was just sharing with someone that I had a file recently where an applicant applied to Canada and failed to calculate her points properly. she waited a year to get a denial from CIC, Canadian Immigration Citizenship. So I really recommend to people that they make sure to have someone else calculate their points.
What are the grounds, like in United States, US immigration laws, there are grounds of excludability, a number of reasons because of which a person can be denied a temporary or immigrant visa. What's the situation in Canada?
In Canada, we have grounds for inadmissibility,
Correct.
depending on whether a person has committed crime or an offense outside of Canada. In fact, it's defined quite broadly. It's defined as committed an act, and we have to ask ourselves, what is an act? We have a system of deemed rehabilitation available so that people can obtain a temporary resident permit to be able to come to Canada even though they have a prior offense on their record.
Criminal record.
Correct. So it is possible to come even though you have that. It just will depend on what the offense was, and preferably if we can arrange to have your offense expunged, taken away. Let's say it happened a long time ago, it was a misdemeanor, it was something very, very small, then we can help the person get that expunged in the US or abroad so that they can then apply to Canada with a clean
So
record.
if a person in the US, he has committed some crime or offense, and under the US laws is a big problem because of CIMT or something like that, it's possible, and Canada is more liberal on that, as you said, they may be able to give a waiver or an expungement, or somehow that person can still be able to immigrate.
That's correct. We have to look at the offense and measure it against Canadian criminal law, which our office does, and we will then determine whether or not that offense is just as serious in Canada or not. It depends on the
See, in
offense.
the US immigration laws, where in the world are you? You apply for a visa, immigrant visa, the time is the same whether it's UK, Canada, India, any place. People ask this question all the time, but I have a Canadian passport, I have a such and such passport. But our system is same line, same waiting periods. What's the story in Canada? In other words, my question is specifically, if a person from the US wants to immigrate to Canada, or a person from India or Pakistan or Bangladesh want to immigrate to Canada, is there different time periods?
Yes, the consulates abroad tend to process a little more slowly than the consulates inland in the U.S. For example, Buffalo. Buffalo processes the permanent residence applications for persons who are on U.S. soil with a valid legal admission. Now, one thing that's interesting to note, Michael, is that if this person had legal admission for 1 year or more, but that admission is now lapsed, therefore the person is, say, on a lapsed H-1B without status in the U.S., that person is still eligible to apply to Canada under the law because they originally had a valid visa, valid for over 1 year.
So what you're saying, we have some clients who came on an H-1B visa, but then they lost the job, or they never were even joined as an H-1B. And technically in the US, we will consider them not in a valid H-1B status. But so for Canada is concerned, that doesn't matter. As long as he is a H-1 valid for 2 or 3 years, and even if he's not working in H-1, that doesn't make any difference, right?
That's
You're
correct.
only looking at the legal status.
It's no problem. They can apply from the U.S., therefore get into a shorter line to wait. And as long as they're applying for permanent residence and they have valid legal admission for 1 year, they can apply for Buffalo.
The same thing you will say a person in UK is a visitor, is a student there studying for a year or two and wants to immigrate to Canada will be faster than applying from India.
It'll probably be faster to apply through London than to apply from India at this time. However, the London consulate right now is taking in a lot of applications from the Middle East. Therefore, London is slowing down.
But Canada is also in a way Commonwealth sister country, so there's a link between UK and also Canada.
That's correct.
What else would you like to tell about Canadian immigration on any particular types of visa which are different here? Like we have L or H or different type of work visas, H2s, Bs. Any particular types of visa which would be easy to get?
Well, the transfer visa, as I mentioned in previous show,
Something like our L1.
like an L1 is an excellent visa to shift somebody north of the border as opposed to going returning home once their visa is about to expire here. We have another class of immigration in Canada called the Canadian Experience class, which is a relatively new program, and it's an excellent program. And it allows a person who's had a job for, let's say, 2 years in Canada and worked full-time at that job in Canada to apply for permanent residence while in Canada.
Can a permanent resident in Canada sponsor the parents? In US they cannot. In US it has to be a citizen to sponsor the parents. How about Canada?
Yes, Canada very much values family reunification, and therefore the laws allow a permanent resident or a citizen of Canada to sponsor their relatives.
That's very nice, which means in the family unification, Canadian laws are more liberal.
Apparently.
Also the time periods, like a husband wife of a green card holders today is taking 4 years maybe. Or the parent or the children married of US citizens are taking maybe 9 years, 10 years. But the waiting periods in Canada are much less, isn't it?
They change all the time, Michael, but currently processing from abroad, outside of Canada, a sponsorship application is facing about 10 months, 6 to 10 months.
Also, we have only 1 or 2 minutes left. I want to know, there have been any changes in the recent years in Canada? In the past, people used to go to Canada on investment visas, that are easy, put in a $300,000, $400,000 in a bank, not even invest in a business, and you get a green card.
Investments are now based on 800, it's doubled in Canada, and 1.6 million net worth. However, entrepreneur programs have been stalled, have been stopped as of July. So I encourage viewers or applicants to look into foreign skilled worker programs, into the classes of eligible occupations. The changes have been very, very great over the last couple of years in Canadian immigration. It's very imperative that they consult a lawyer to know what the current law is.
And I'm sorry to say that 800,000 and million is not much of a difference. I'd rather get you guys 200,000 more, get a green card based upon $1 million or even $500,000 investment in the US. With that, I think we are running out of time. We come to an end of the program. We thank you very much, Malika ji and David, for coming on the program. I'm sure we're going to invite you again and again, because I know lots and lots of our viewers are going to come back and say, where is Veronica, where is Veronica, where is Malika? So we'll be back. Stay tuned for the next Saturday at 1 p.m. We will be back with Mr. David and Veronica.
Thank you.
Thank you very much for watching the program.
When writing your questions to us, please let us know.